do it.
And
As probing. Our job is to get to the issue.
I gotta know.
Because people coming to us, they come in with the mask on.
Yeah.
I've done everything right, and so we have to
I gotta know, dog.
And get behind.
I gotta know, man. But see, but they think that is because you're asking those tough questions.
That's right.
And even in bankruptcy, I'm asking these tough questions.
True.
And you don't believe me.
True. That's exactly right.
Like I say, is this all you got?
That's right.
Is this all the debt you got? What? But you think I'm lying?
That's right.
No,
That's right.
I'm trying to figure out if, why are we here on chapter 13 or chapter 7, and you only have a little bit of debt here?
That's right. Well, whose side you on?
Yes. You're
supposed to be representing me.
Yeah.
You must be on their side.
Or they'll just, I've had people, man, just say, you know what? I'm just not going to do this, and get up, and leave.
Right.
I can't believe I spent $100 for this, because I got the cheapest consultations.
You should do.
You should. They say, I can't believe. I said, let me tell you this. I'm sorry you feel that way, and that's not my intent. Right. But I ain't tripping about the $100.
Right.
Go to the front desk, give me your receipt, and they'll give it back to you. Because I got to make sure you want to be here
for sure.
And Jerome, I don't know about bankruptcy, and yours are free consultation.
It's free.
Free consultation.
Free consultation.
How many times have people scheduled and don't show up?
All the time.
See, so now you've blocked out that time in your calendar, and dude, time is for us. You can't never get it back.
I tell people all the time, as attorneys, all we have is time to sell. And if I block this time out for you and you don't show, that means that someone else who really needed the time can't get in because you done screwed it up. Yeah. So,
dude, my calendar right now was December the 5th, 6th?
This is the 6th.
I don't have any vacant appointments until December the 28th.
Look at you, man.
That's what I'm saying.
That's right.
No. What my point to you is, so if you schedule an appointment and don't show up, you just cheated somebody else out of a time that really needed that time, and and like you said, you need a bankruptcy right now. You need a chapter 13, chapter 7. Dude, they just drove off with my car on a tow wagon. And I can't get to work tomorrow.
That's true. Yeah.
I'm already right here. And they just took the one thing that helps me get back and forth to work.
Right.
And if I don't get some help, it's going to be bad.
Well, because I'm going to slip further and further into the misery. Because I didn't get a chance to get in order to get the relief that I needed.
So if I call you and you can't see me because you don't have any spaces or positions, because this other person booked the position that's not going to show up.
Right. That's right.
That guy right there is in a bad scenario.
That's exactly right.
Bankruptcy is a different, I don't want to call it an animal, but it's a different.
Well, it is. Yeah, it's a different. It's a tool.
Yeah.
That's what we, and I talk to people all the time. I said, when you come in to see us, we have a tool box that's available. And so based on what your needs are, will determine what tool we have to pull out. Sometimes it's an injunction, but sometimes it's a complaint, sometimes it's a phone call. Because one thing too there about a seasoned attorney like yourself and I am, I'm gonna still eat regardless of whether you purchase. You know what I'm saying? Whether you hire me or not, I'm still going to eat. So I'm not gonna rush you into a situation where you don't really need to be.
All right.
So, and I tell people
that all the time.
I tell them all the time, hey.
Matter of fact, I don't. Other than your consultation fee, I don't take money on the first visit. I just don't. I mean, you can't. We can talk about it, but you can't retain me. On your first visit in my office, you cannot retain me.
That's great.
Because I want you to go home, and I tell them.
I heard you say this before. I heard you say it before.
Go home. Think about this.
I heard you say it before.
Because it's other people out here that are better than me.
Right. I heard you say it before.
Yeah. Go out there, look, check, research, do all your stuff, and if you got to come back after that, come back, sign the contract, get your money right.
I hear you. And so the other thing too, there is that what we do is when we're probing, it's looking for issues. Because as you're speaking, when we're writing down whatever the conversation is about, we are pointing out the issues that need addressing. All right. So the main thing that we do in debtor-creditor world is to make you look in the mirror and see the person who caused you to be in that situation. And it's the man or woman in the mirror.
Do you ever see, Jerome, let me ask this question, because I see this more on a lot of what I do. Do you see a scenario where you could represent yourself in a bankruptcy? Because you can legally, right?
Of course you can.
Okay.
Of course you can. I know all of the things. I do it every day. But he who represents himself has a client.
As a fool
for a client. Because you're too emotionally involved in it. And you inevitably you're going to miss something because of the emotions that's attached to it.
And lawyers miss stuff. Even and that's their only one job is to take care of your case.
That's right.
And they still miss something.
That's right. And the other thing about it too is that because of the emotions that involved many times, it makes you not be reasonable.
Oh, yeah.
A lot of times, because your expectations become what? I can't fulfill your expectations. So a lot of times we want to know, what do you expect out of this representation? This is what I'm offering. Somebody might say, I saw where a lady got $1 million for a coffee spill on at McDonald's. Ma'am, that ain't gonna happen. You don't have $1 million case.
Hey, look, I got a good question, Jerome. Sure. Here we go. A friend owes me $30,000. Here's the good thing.
Yeah.
I have an IOU.
Okay.
Good.
Okay.
They claimed bankruptcy in 2016. They made a few payments in 2023. Can I sue for the remaining? I think the short answer to that is yes.
Well, women there, you heard it said they filed bankruptcy.
Okay, so here we go.
You can't collect on the debt.
I bet you can. Watch this. See, look at that. Look at that puzzle, boy. I bet you can. So here's what happens. Check this out. The person owes me money. Guess what? They got a contract now because they got an IOU.
Okay.
So they have a document that establishes the debt.
Okay.
So we agree on that?
I agree with that. Yeah.
So we got a contract.
I agree with that.
Now, they filed bankruptcy in 2016.
Okay.
Now, the question becomes, if they filed bankruptcy in 2016, did they claim this $30,000 as a debt? See, bankruptcy doesn't automatically wipe down stuff that you ain't never claimed. So did they put this on their petition?
Let me tell you this. So let's say this first of all. Always walk cautious when you hear the word bankruptcy.
Okay.
Because there are several types of notice, and you know that too.
Yeah.
There's inquiry notice, there's actual notice, and then there's written notice. So inquiry notice is where I hear this going. All right. That means that somebody has said that they filed bankruptcy. Based on that, that's enough for you to call the court or something to find out if it's true. All right. And then you can see the list of creditors based on that and see if that debt was listed. All right. Now, the next thing there is that IOU is an unsecured debt.
Right.
You don't necessarily have to identify all unsecured debt.
Okay.
Because the bankruptcy estate includes everything that this debtor has.
Correct.
All right. So that unsecured debt is a part of the bankruptcy, regardless of whether or not it was actually
look at you teaching your boy.
Yeah.
All right, so let's back up for a minute.
Okay.
Just because you file bankruptcy doesn't protect it, though, Jerome. Let me tell you the reason.
Okay. All right, I'm listening.
Here's a question. Here's a fact that's missing in this fact pattern.
Okay.
Did the guy get a discharge?
True. Just filing bankruptcy won't do it.
Yeah, because if they didn't get so say for instance, they filed bankruptcy, they did not finish
Oh,
the plan,
okay.
then they didn't get a discharge.
No, then that debt
Okay.
is active. Is still available for collection. Yeah.
Yeah, and that was the other question I was going to ask, because Jerome, if you make a payment to me after the bank, see, that's where I'm going.
That is.
I don't, I'm that guy.
That's good.
I'm that guy.
That's good. That's
Because
good.
look, check this out.
That's good.
Here's what I
That's
would have.
good.
Here's what I would have saw. Even if this person hadn't filed bankruptcy, here's what I would have saw.
Mm-hmm.
The IOU was predated 2016.
Mm-hmm.
Okay.
Mm-hmm.
Let me just say, I'm a real lawyer, man.
I
Let me
got
just, so it predated 2016.
Right.
And in 2023, he made the first payment.
Mm-hmm.
My argument would be that the contract expired in 2022, whether he filed bankruptcy or not.
I got you.
But by making a payment, he revived the contract.
I think you are right. I think there is I'm not saying that you're right. I'm saying that there is an issue.
Yeah.
Because a lot of times we have to tell elderly people to be careful about that, because they start to feel bad. They had maybe a little grocery store around the corner where they would allow them to come in and get groceries and stuff, and just put their name down on the book.
Mm-hmm.
Or it used to be a little place called Mitchell's Clothing Store where you could go in and get a suit or something like that.
Put shoes on layaway. Yeah.
And so because you are required to list all of your debt when you file a bankruptcy case, and we have to tell them that it's going to be discharged. Do not make a payment, because they start feeling bad about it because Mr. John was really nice to them. And then if they do make a payment, you can revive the debt again.
Well, and I think that this, because what this person said is they got a letter stating that the bankruptcy was dismissed.
Oh, if it's dismissed, then no.
See, dismissed is different than discharged.
Absolutely.
Dismissed means that there is a failure on behalf of the debtor, which required the court to make the case go away.
But the other thing is because you are now coming after them and the case was dismissed, there's nothing to keep them from going back and filing again.
No, it's not.
Yeah.
Well, yes, right. That's the problem here.
And that's usually what's going to happen.
It is. Oh, it is. I mean, look, bankruptcy can be a shield and a sword at the same time.
Absolutely, yes.
I mean, and it's a good thing.
Yeah.
The shield of it protecting you from all these other things. The sword of it is, if somebody's coming at you wrongfully, I'm going to attack you.
Well, but the other thing too, Darryl, is what it does. It also gives you some leverage in dealing with the creditor.
Yeah.
So, all right now.
All right, dog.
You keep on pressing. You want to
keep on pressing.
Now I can pay $250 per month, but you keep insisting on you got to have $500.
Right.
All right.
Right.
Don't let me call Jerome back. because what? A bird in the hand is worth two in the bush. Because if you pressure someone and to make some payments, and you can pressure them so much so until they do make those payments. Mm-hmm. All right, man, $500. And then we can go back for 90 days and get every dime that you pressured them into paying, because you're doing it under duress and stress. So that money will come back. So it gives you that leverage to work with. I tell people all the time too, say for instance, like even with creditors, I'm not gonna call the name of some furniture companies, some appliance companies will let people have stuff like a lease or ask you to pledge your goods in order to get a check. All right, so when that person does that, that's somewhat of being a secured debt after that point.
I think so.
But I tell them all the time, I said, what you have to do is act like you don't care about it. Come and get it.
Yeah. Right.
the lawnmower or the TV or the VCR.
They don't want it.
Come get it.
Yeah, I don't really want
And
it.
9 times out of 10, they ain't coming.
They ain't coming.
But they might call back and say, well, you know what? I know you owe me $5,000, but can I put in $250?
Yeah.
$2,500? Or the interest rate was 26%. What about if I knock all the interest rate out? So it gives you some leverage. And that's what I'm talking about, the tools that are available to help you get to your first start.
You know, Jerome, I got another good question
Okay.
here. And I see this all the time. Can a creditor garnish my Social Security bank account if that's my only income?
Absolutely not. Even if it wasn't your only income, they can't take your Social Security.
Right.
Period.
Yeah, so, and I tell people, I'm glad we're on the same sheet of music.
Yeah.
I tell clients all the time, if you have Social Security, that cannot be touched.
Careful.
Yeah, you go. You know where I'm going with
You
that.
can only have Social Security
There you
money in
go.
there.
There you
Nothing
go.
else. If your children every now and then they try to give you a little gift so you can pay these bills, and because it would have been you co-mingle the funds, and so the creditor can very easily say, I don't know what Social Security or the other $200 in there.
Well, here's the thing about it. It doesn't matter because if that account, okay, so it's my account, and you ask me what's my source of income, and I say Social Security, okay? You can't prove that that's not my only, I mean, that's what I'm telling you, right?
Well, first of all, Darryl, the bank is going to let them garnish the levy on it. That's a levy.
Yeah, but the bank will the bank will let them do the levy, but when I provide you, I would provide, not the bank, I'm going to provide the person who garnished my wages proof that my only source of income is Social Security.
But you had more than Social Security in your account.
You don't
can't have
know
it.
that.
You can't have it. Yes, I do. I know that because the bank allowed me to do it.
The bank doesn't get into it. They will still let you, the bank will let you go into Social Security. They don't care.
The bank does care. The bank should not allow a person to garnish Social Security.
They don't do that. They don't care. What they do is they see a levy or a lien on, and they'll let them go in there and get it. Yeah, and what happens is you have to approach the creditor that went in there and took it out and say, you go in this Social Security funds, you put my money back.
Well, you can file a motion to quash.
Yeah.
But the bank should never, ever allow a levy on an account that only holds Social Security money.
They should not.
That's federal law.
It is a federal law.
Right.
But the issue is this. When somebody gets a levy, unfortunately, they don't send you notice that they're getting ready to levy on your bank.
That's true.
So you don't know that they're trying to levy on your bank.
That's true.
Because when I send out a subpoena on somebody's bank account,
Right.
I have to, the bank notifies them that I sent a subpoena,
Right.
and they got a certain period of time to actually object to it.
That's right.
Doesn't happen with levies and liens. They go and do that, file their levy, and take it to the bank right now, and the bank freezes and take the money out right then. So you have to put the person who's trying to get them funds on notice.
That's
hey,
true.
Dog, you just garnished my money.
That's true.
All I get is Social Security disability.
That's true.
You didn't put my money back.
That's true.
And you provide them with a copy. I'm not going to provide you each transaction in my bank account because I may get Social Security every week, right?
Right.
Or every month, rather. And at the end of the day, my bank account is just building up because I'm not spending my money. So I may have $10,000 or $15,000, and it's all with Social Security money.
Well, that's untouchable.
Exactly. Now, if I get two sources of income and I put them in there,
Right.
Still, they got to try to figure it out, But
so to end all that, the best practice is don't put anything else in that account.
Okay, that's what it all boils down.
And then you don't have to have anybody try to
right. Social Security money,
That's right.
or disability money
That's
should
right.
go in a count of its own.
That's exactly right.
All right, y'all. Thank you for watching the show. Hey, we got some pretty good questions today.
Sure did, man. That was exciting. I love that.
So thanks for watching the show.
Yeah.
And we'll see you back next week.
Can you actually imagine hosting your next event at the all-new SVP Banquet and Event Center?